2002 media coverage order. To courtroom observers, jurors have a duty to decide this case based only on the evidence presented. To ensure that both parties receive a fair trial, it is my duty to minimize the risk that jurors are influenced by external factors. For that reason, courtroom observers are prohibited from wearing clothing or accessories with political or social justice messaging. If you are currently wearing or displaying anything that meets that description, please cover it up or put it away. Thank you for your cooperation. And to the parties, the court's received a couple of motions from the parties, one from the defense and one from the state. So I'll go ahead and start with the defense.
Our motion, Your Honor, is a motion to dismiss.
Count two.
And
I was going to ask about that because I thought I heard you say toward the end of yesterday you were going to renew the motion on count one, and then you had filed some documents about count two. So I wanted to clarify if I heard correctly, or if that's what you intend to do on count one and count two.
Correct.
Okay. Anything else from the defense?
If the court would like to take our motions up first, that's fine. I don't know if the state wants to argue their motion first.
Yeah, that's what I want to hear from them as well. But I want to hear if there's anything else from the state that I should know that may be coming other than these two motions at this point.
Not at this time.
All right. State.
Your Honor, to be clear, may I sit?
Yes.
It's
And I can count. You have chosen to stand sometimes, be seated sometimes. I don't have a preference in that, and so it's whatever, if counsel's comfortable with one or the other, I certainly am. It's not a matter of showing disrespect by standing or sitting. And sometimes in particular when you're reading your notes, it's easy to sit, and I just am more interested in what you have to say than whether you stand or not. So the parties don't need to ask for permission one way or the other.
Thank you, Your Honor.
Thank you, Your Honor. The first Superior Court judge I ever had a trial in front of was not happy when I forgot to stand. So since then, I've just made it my practice to do so, but it is a lot easier to be able to read the notes. So
Fortunately, this is a district court, perhaps.
well, I don't know that was the difference, but thank you. Your Honor, just to be clear, our motion is a response to their motion. So yesterday, the state rested its case on December 7th, which was last Wednesday. And then yesterday at the end of court, literally at the end of court at 4:26, they filed a halftime motion 6 days after the state has rested. And the nature of that motion is an argument that there is insufficient evidence to prove that Mr. Shadle is a public servant. And because this is a halftime motion, the state, of course, I'm not going to go back through the case law, which the court is extremely familiar with, but it is, because it's a halftime motion, the court's required to look, to accept the truth of the state's evidence in the light most favorable to the state, and all reasonable inferences from that. Now, the motion that was filed yesterday, 6 days after the state rested, is an argument that there isn't sufficient evidence in the record to prove from which any reasonable juror could find that Mr. Shadle, the dispatcher who took Sheriff Troyer's call, is a public servant. We believe that is incorrect. The evidence in the record, and I understand they've made argument outside of the record, going to a website, arguing over what the term agency means, but for purposes of the motion, what matters is what's in the record. And what's in the record is testimony from Mr. Shadle that he is an employee who works for a county agency. And that is sufficient to allow a juror to reasonably infer that he is an employee of government. Now, the state has also asked to reopen its case to alleviate any alleged lack of clarity in terms of that record. And case law is very clear in Washington that it's in the sound discretion of the trial court to allow that. Now, we have Mr. Shadle, unless he's told otherwise, is going to be here at 10:15 today. This would literally take 5 minutes to ask him a few clarifying questions about who pays him, who employs him, and that he's a government employee, which he's in the best position to know since he's the one who knows his status. Now, whether a party in a criminal case can reopen like
Let
this.
me stop you there and interrupt for just a second. At this point, I do want to hear from the defense as, it sounds like the state the state's preference is to proceed with its motion to reopen rather than the court proceed with the defense motion to dismiss count 2. Is that accurate from the state's perspective?
Yes.
All right. I want to hear from the defense about which motion I should hear first before we get into argument as to what the motion may entail.
Understood, thank you.
All right, so, Mr. Gross, defense response about which motion should proceed first.
We'd prefer to move forward with the motion to dismiss, and then we would reserve the right to respond to the state's motion to reopen if the court entertains that.
The court agrees with the defense. That would be helpful to, I should indicate, the parties have filed pleadings. Thank you for that. That's very helpful for the court. I've had a chance to review the pleadings, review the case law that the parties have cited within the pleadings. I did that last night. And so the court's prepared to hear the motions, but the defense, but the state's indicated their motion to reopen is in response to the defense motion. So it'd be the court's preference to hear the full defense motion, hear argument about that, and then potentially proceed into the state's motion to reopen. And so with that, I'm going to switch from the state over to the defense so defense can, and let's hold off on the motion, the insufficiency of the evidence motion on count 1. Let's just focus on count 2 right now, since that seems to be the only basis the state's asking to reopen its case concerning count 2, the making a false or misleading statement. So with respect to the defense motion to dismiss count 2, Mr. Gross.
Thank you, Your Honor. The state is charged in count 2 the crime of making a false or misleading statement to a public servant. An element of that crime is to prove that the person to whom the allegedly false statement was made was a public servant. And the person alleged here is Conrad Shadle, who is an employee of South Sound 911. The term public servant is defined by statute, and for purposes of this hearing, or for this case, well, it defines a public servant as either an officer of government or an employee of government, and it gives some examples of who might qualify for that. There's no evidence, and I don't think anyone is suggesting that Mr. Shadle is an officer of government. An officer of government is essentially someone who holds office. So the question then is there any, so what they have to prove in this case is that Mr. Shadle is an employee of government. And our motion is quite simple, which is that the state has produced no evidence during this trial that Mr. Shadle is an employee of government. The only point in the evidence in this case for the topic of, well, Mr. Shadle testified that he's an employee of South Sound 911. And as argued in our brief, the name South Sound 911 in no way indicates that South Sound 911 is a government entity. I mean, in fact, it sounds like a private company. It's not the Pierce County Department of Dispatching Services or anything like that. It's called South Sound 911. And the fact that South Sound 911 provides police dispatching services does not mean it's a government entity. There are plenty of jobs in government, or there are plenty of jobs that are from private companies that contract with government to perform government services. So, and I provide in our brief several sites that show that there is a sort of an uprising of private 911 dispatching companies and government entity or government jurisdictions that having budget issues that are now contracting out with private companies to take care of their dispatching services. So the fact that they provide dispatching services does not indicate that they're a public entity. So I think as is obvious that as they have the burden of proof, what they need to prove is that Mr. Shadle is in fact a government employee. The only evidence that came out in this trial about what kind of an entity South Sound 911 is when Mr. Shadle said, quote, well, he said South Sound 911 is, quote, an agency that provides law enforcement dispatching 911 services for the county. Again, there are plenty of roles where people provide services for the government. That does not mean that they're a government employee. And we cited the case of KLB, which is directly on point. In that case, there were government fair enforcement officers who were contract employees from the private company Securitas. The state charged a person with making a false or misleading statement to a public servant because they made a statement to that private contracted Securitas officer who was a fair enforcement officer. And the state argued that this person was a public servant because he was performing a government function. And the court held that the fact that someone performs a government function does not make them a public servant. And only those who are actually employees of the government are public servants. So, again, the state has failed to present any evidence that Mr. Shadle is actually a government employee. And I just heard the state suggest that as sort of a summary that has a summary of what Mr. Shadle said, that Mr. Shadle testified he's a county employee, and that's false. If the state is arguing that Mr. Shadle is a county employee, then I think the record needs to be corrected on that. I don't think we can let demonstrably false statements go to the jury. He's not a county employee, and he didn't say that, first of all. He said that he works for an agency that provides services for the county. But I think I'll stop there. This motion is about lack of evidence, and the state has provided no evidence that Mr. Shadle is a government employee.
How would the defense, let me take a step back here. RCW 9A04.110 defines public servant in paragraph 23, and the defense cited that in its motion. And it's a pretty long definition of public servant, but toward the end of the definition, the statute reads, after talking about elected officials, that type of thing, says, quote, and any person participating as an advisor, consultant, or otherwise in performing a government function. And KLB talks about that. And so, of course, interested in the defense perspective of KLB talked about it, held that this fair officer was not an advisor, consultant, or someone that involved that, but didn't really define those terms. And so if the defense has a thought about what advisor, consultant, or otherwise would mean and how that would be defined in the context of this case and South Sound 911, that could be helpful to the court.
Your Honor, I didn't see any definition of that either in the case of KLB, but I think as a matter of common sense, Mr. Shadle is a person that is not an advisor to government, a consultant for or consultant for government or otherwise. Just like a fair enforcement officer, he's a person that directly discharges his duties for the government, which is to perform a specific service, a specific narrowly defined service. He's not a person that participates in giving advice to the government about how to handle certain public policy matters or policy matters. So I don't think there's any sensible argument that Mr. Shadle was an advisor, consultant, or something similar to the government.
In KLB, the state made several arguments that were rejected, and one of the arguments was that, well, if someone lies to a fair enforcement officer, theoretically there would be no crime for that if the court ruled how it ultimately ruled, and the appellate court's response seemed to be, well, then law enforcement could be called, they are public servants and would meet the definition, and so this individual, if law enforcement were called and then that individual lied to law enforcement, that would be a crime. The state's concern there seemed to be that there wouldn't be any action that could be taken from lying to a fair enforcement officer. Here, count one is false reporting, and I'm interested in the defense perspective. Would the defense perspective be that the false reporting, that false reporting to a 911, to South Sound 911 dispatcher would not be a crime. And I'm trying to link between these two different crimes, because in KLB, the state was saying, well, there wouldn't be any crime at all from lying to this fair enforcement officer. It looks like in this case, regardless of count 2, that in fact, if an individual did contact South Sound 911 and give a false statement, that in fact a crime could be charged under false reporting, even if it could not be charged under making a false or misleading statement to a public servant, because South Sound 911 is not a public servant. And I just want to see if that's a defense perspective at all, or is it that because the South Sound 911 dispatcher is not a public servant, this would also tie into the defense motion on false reporting?
No, this motion is specific to count 2, if that's the court's question.
Okay. So from the defense perspective, if Mr. Shadle is not a public servant as defined in count 2, that wouldn't mean that one could false report or give a lie to a dispatcher and that wouldn't mean there would be no potential criminal liability, because you would have false reporting, assuming it was emergency response and all the other elements of false reporting. So it's not like the fair enforcement officer where there wouldn't be any criminal activity by lying to that individual.
I don't want to make a definitive statement that I agree with that. All I'm saying is that I'm not arguing right now that this public servant argument applies to count 1.
Okay.
Right line. I know you're not there yet.
I'm just saying that.
Anything else, Mr. Brooks?
No, but I reserve the right to respond to all these arguments.
For sure.
Thank you.
State.
Thank you, Your Honor. First of all, I'd like to make clear, it makes sense to do it in this order, but I do want to state that I don't think the motions here are mutually exclusive. The court can and should find in favor of the state that there's been sufficient evidence from which any reasonable juror could infer that Mr. Shadle is a government employee. And yet, even with that in mind, the state can still move, as it is, to reopen its case. And I'm not going to read the brief into the record because I know the court has read it, but there are numerous cases where the state has been allowed to reopen its case, which here we're asking to do for an extremely brief period of time.
For now, the state could focus on the defense motion to dismiss because of insufficient evidence of count 2, and then we'll get to the reopen. And arguments could be permitted for that, but I want to hear the state's response, particularly with respect to how the state reads KLB, given the definitions that the defense has talked about in RCW 9A04110 concerning the public servant aspect.
Right, so, Your Honor, there's 2 ways under the statute, which I know the court's looking at. I think it's subsection 23. One is that you can be an employee of government, and the other one is what KLB addresses. Those are 2 different ways to prove government, 2 different ways to prove public employee, and KLB only addresses that second way, and it does indicate consultant, advisor, or otherwise. I think there's a reasonable argument to be made that the otherwise would apply to Mr. Shadle, but the court didn't seem to say that. The court does seem to attach that word to consultant or advisor, and the state agrees that it would be difficult to argue that a dispatcher is a consultant or advisor, and it's the state's intent to argue under the other way that somebody is a public servant, which is being an employee of government. Now, we haven't had a chance to go back and listen to the record. Again, this was dropped on us yesterday, but the quote that the defense put in their brief, and again, Mr. Shadle's testimony was quite a while ago, so I'm going to have to just rely on that, is that South Sound 911 is an agency that provides law enforcement dispatching 911 services for the county. That is the only evidence in the record, and a reasonable juror could find that when somebody says they're working for an agency that provides services for the county, that that person is an employee of the county, meaning an employee of government. Now, they are certainly free, and again, this is a halftime motion, so we're entitled to all reasonable inferences. They can certainly argue to the jury, but based only on the evidence in the record, about, well, he said the county, and, you know, maybe it doesn't mean that, it could be something else, but they'd be limited to what's in the record, just as we are limited to what's in the record, which is that he works for an agency that provides law enforcement dispatching services for the county. That is what's in the record, and that is easily sufficient for a reasonable juror to infer that he works for a county, that he works for the county, which makes him a government employee. It literally says the county. That's the state's argument.
Defense response.
I guess I'll just say again, it sounds like what the state is suggesting is that the evidence that from which a reasonable juror could find beyond a reasonable doubt that Conrad Shadle is a government employee is that he's a county employee. And that is false. That is simply false. And so that reading, it's not a reasonable reading from what he said. What he said is far more vague than that. But also, if they plan to argue that Conrad Shadle is a government employee, I think that would be a matter of prosecutorial ethics, because they know that that's not true. And that's not what the evidence says.
Juror, I have to respond to that. Are you done?
I'm done, yes.
I specifically asked Mr. Shadle if he is a government employee. It wasn't in court, but I can guarantee you that he will say he's a government employee, he's a member, he gets paid by the county. He is under PERS, which is the Public Employees Retirement System, which is the same thing that Serrano and I are under. He will say he's a government employee. And I had those questions in my script, which I'm happy to pass over, but once he said that he worked for the county, I felt that that was sufficient, and I didn't ask those other two questions. But they haven't even interviewed him, Ms. Serrano and I have. He will say he is an employee of government, that he's a government employee. We also interviewed Ms. Heiberg, who also said that she's a government employee. So it is not a lie to say that. Either one of those two would testify to exactly that fact.
Mr. Gross.
A government employee is different than a county employee. And what the state is suggesting is that they would argue that he's a county employee. My point is that's not true.
How is the county not government?
The county is government. My point is that just because he's a government employee doesn't mean he's a county employee. And he's not a county employee.
He said he works for the county. Sorry.
Anything else from the defense?
No, thank you.
Thank you for those clarifying comments for everyone. I have to admit, I didn't anticipate exactly the argument you both have made, so I'm grateful that you both enlightened me more from the pleadings that were filed. All right, with respect to the court's going to reserve ruling on the defense motion to dismiss count 2, so now we'll go ahead and switch over to the state and the state's motion to reopen its case. State.
Here, I'll be brief because I know that the court has read the brief, and I don't want to simply recite what's in the brief. But what's in the brief is that there's no question that it's in the sound discretion of a trial court to allow a state to reopen its case. Here, that would be literally for just a few minutes, and as I said, the witness is going to be here at 10:15. And under the Brinkley case, that case lists the factors that a court should consider in whether or not to allow the state to reopen its case, and I've applied all of those on page 4 of the brief. But additionally, I'd note that we listed numerous cases. A lot of them are uncited because they are basing their rulings on Brinkley, but that simply indicates that there's no dispute that whether or not the state should reopen a case is in the sound discretion of the trial court. And these cases that we cited, where the court has allowed the state to reopen its case, we specifically looked for cases where it was allowed for further evidence after the defense had moved for dismissal on the basis of insufficiency of evidence, which is the legal juncture we're at now. And some of those cases allowed the state to reopen for things that would be fatal. For instance, in the first case that we cited, State v. Hunt, the state was allowed to reopen its case when it turned out that nobody had identified the defendant as the perpetrator, which, as the court knows, would be completely fatal to any criminal case. We've also cited cases where the state was allowed to reopen to cure evidentiary deficiencies. We've cited cases where the state was allowed to reopen, for instance, Killian, where the defense moved to dismiss because the state had failed to provide an essential element of a no-contact order violation. The court allowed the state to reopen there. Lizarga, Canche, where the state was allowed to reopen after the defense, again, moved to dismiss for failure to prevent testimony to prove a bail-jumping charge. Here, the state is simply asking to reopen for a very short period of time to bring out a little bit more evidence on the public servant issue. And I think that as long as this trial has dragged on, it is a reasonable request for the state to be allowed to do that when it has its witness ready, when it would take very little time, and when we're doing so in response to a motion that was dropped on us yesterday. This would have been more appropriately filed at the end of the state's case in chief on Wednesday, at which point we could have just brought Mr. Shadle back then. It's a reasonable request, and the state would ask that the court grant it.
Well, here from the defense, I should disclose to the parties, the Brinkley case is a case out of Kitsap County with Judge Cruzy, and as you know, I've been a lawyer and judge in Kitsap County a really long time, and this case it's not infrequent for the state to cite this case after it got published in Kitsap County courts. This is a very well-known case in Kitsap County, and I just think it's fair the parties know this is, when you cited to reopen, when I read that, I immediately thought of this case just because it's something that's become not routine, but it's not unseen, and I just think that's fair. I disclose to the parties this case is cited a lot by the state in certain circumstances. So I just want to tell that to the defense before you make your argument.
Thank you, Your Honor. Before I address the prejudice and the factors for whether or not this court should reopen this case, the proposed testimony that the state is suggesting should be admitted is not admissible. Mr. Shadle already testified who he is and that he's an employee of South Sound 911. What the state is actually intending to call him to testify to is that South Sound 911 qualifies as a government entity and meets the definition of a government employee. That is a legal conclusion that he's not qualified to make. This is not a situation where Mr. Shadle is simply an employee of Pierce County, where the fact that he's a government employee would be obvious. South Sound 911 is a very unique entity. And this is just the result of very brief research on what they are, primarily from their website. They are the result of an interlocal agreement between a number of counties. They've switched their governance form already since they've been in existence. They are run by a board of directors who a executive director reports into. They, from a brief review of the statute that their website cites to about what they are, that they're a public development administration, it looks like they're independent contractors. The statute limits their liability, and it limits their liability and indicates that which indicates they can be directly sued and sue.
What statute is that?
RCW 35.21.730 to 755. The one I cited is,
Isn't Title 35 county government?
what's that?
Isn't Title 35 county government?
Well, it's cities and towns. Title 35 is cities and towns. But I think what the statute says is that cities and towns can utilize this statute to create this other thing. It's not saying that this is a city or a town. I just, there's a website called MRSC, and I'm not representing that I know anything about what this website is, but it,
Court does.
okay, well, fortunately the defense doesn't, but it talks about public development authorities, and it says, it calls them special purpose quasi-municipal corporations. So the point is that what this thing is not a matter for for a lay person to testify to. In fact, after I've spent half an hour researching this, and I can't say whether or not they meet the definition of a government entity as defined by the WIPIC. And the WIPIC says, this is the WIPIC that the state proposed, government includes any branch, subdivision, or agency of the government of this state, and any county, city, district, or other local government unit. So what they want Conrad to testify to is that this extremely complicated quasi-municipal independent thing meets the definition of a government entity. And that's just something that he's not qualified to testify to. So because his testimony would be inadmissible anyways, I'd ask the court to deny the motion.
State response.
Your Honor, he has personal knowledge of who he is and what he is. When the state directly asked him during their interview with a government employee, he said yes. He gets paid by the government, he gets government benefits. This is not a legal conclusion, this is literally asking a person, it's like if I called Ms. Serrano to the stand and I asked her who she works for. He has personal knowledge of who he is and who he works for and what he is. And that's all that the state is asking. That's not a legal conclusion. That's testimony based on the personal knowledge of the witness in the best position to testify who he is and what his status is.
To Mr. Gross, if the court grants the motion to reopen, would the defendant suffer greater damage than had the state sought to admit that evidence in its case in chief?
Yes.
Explain, please.
Sure. The first thing to point out is that the state didn't disclose under Rule 4.7 that anybody would be testifying to what South Sound 911 is. And again, the fact that this is not a straightforward answer matters, because...
Does it matter that the defense did not interview Mr. Shadle with respect to that topic about discovery?
No, it doesn't matter, because they didn't disclose that this is the point, they didn't disclose that Mr. Shadle would be testifying about that. If they had said Mr. Shadle is going to testify about what this government entity is, then the defense would have interviewed him. And further, the defense, this is not our area of expertise, how the inner workings of these intergovernmental entities. And so the defense likely would have had to consult with an outside legal expert, someone from another firm that works in this area to discuss what this is. So we have been prejudiced by their failure to disclose under 4.7 that anybody would be testifying to this topic, and the fact that to move to reopen now, we would be prejudiced because we are not in a position to obtain a legal expert to consult about this and potentially testify about this.
Would a continuance solve that problem?
continuance could solve that problem. It would give us the, it would,
If the defense needs more time to do what you're suggesting, would a continuance solve the issue with respect to the defense inability to be prepared to answer this question?
a continuance would solve the timing issue, but it would not solve the prejudice issue. For one, this, Mr. Troyer is paying for this defense out of his own pocket, so as the amount of resources, further resources that he would need to expend, would prejudice him. And the timing of this case is near its conclusion. This is a very stressful case for my client, and he does not want this case continued. The state had 2 years to prepare for this. They had ample time to present all of the evidence they needed to support their charges, and the expense and emotional prejudice that this continuance would cause my client is prejudice. And that's not to mention the fact that this was not disclosed under 4.7.
Anything else from the defense?
No.
State's motion, last word?
Last word, Your Honor. It's not prejudice that he's paying for his defense. Mr. Shadle is simply going to give his layperson, personal knowledge statement of who he is and what he does. And they are free to cross-examine him about the validity of his self-identification, that he's a government employee.
The court is going to grant the state motion to reopen and still reserve the defense motion to dismiss, which can, if and likely will be raised after Mr. Shadle and any other testimony is elicited on this particular topic. It's premature for the court to rule now on the defense motion. I'm not going to deny it because it's premature. I need to hear what the state may want to present when it reopens the case. With respect to State versus Brinkley, 66 Washington Appellate 844, 1992, a Kitsap County case. The appellate court made clear different factors that the court could consider in deciding whether or not to grant a state's motion to reopen. Specifically in the case, it mentions a case called In Re Estes versus Hop, and that's a case where a Washington court prior to Brinkley had held that the court did not, the court properly granted a state motion to reopen the case to present additional evidence after the defense moved for dismissal on the basis of insufficiency of the evidence, and that's what's happened in this case. So that Estes versus Hop case cited in Brinkley is germane to is on point with respect to what's happening here. In looking at Brinkley and what the court should consider the factors, it's whether the defendant has excused witnesses who would have been used to rebut new evidence being offered. The court's not heard anything from the defense that they've excused any witnesses. Whether the state deliberately withheld the additional evidence until a late stage. The court finds that's not accurate. With respect to the discovery that violation the defense presented, the defense was and is aware of count 2 and what's been charged as making a false statement to a public servant, and the name of the crime is the phrase public servant. The defense was provided notice by the state that it was going to call several members of South Sound 911. The defense was aware that the phone call made from their client to South Sound 911 resulted in a response and would result in a response, and so the defense is aware of the fact that South Sound 911 is going to be a subject of a issue or subject to be discussed in this case, as well as an employee or employees of that agency would be testifying. So there was no discovery violation. Defense also chose not to interview Mr. Shadle despite being given the opportunity to do so. The court finally finds that the defendant has not suffered greater damage than would have been if the evidence would have been offered at the proper time. That's the Menke case cited in Brinkley. And so for those reasons, the court is going to grant the state's motion to reopen concerning witness Shadle. But again, I'm going to reserve, after the court hears that evidence, reserve whether or not to grant the motion, the defense motion to dismiss. Depends upon the testimony the court hears.
Will the court address our argument under 4.7 that this was not disclosed and that's prejudicial?
Yes, and the court just did. There is no discovery violation because the identity of the witness was disclosed, the identity of where the witness works was disclosed. The defense was certainly aware that their client made a phone call to South Sound 911. The defense was aware that the charge involved a false or misleading statement to a public servant, which could have only been South Sound 911 dispatchers, and so the defense would have had all that information. It's not a matter that it was disclosed by the defense, the case disclosed it, and their client allegedly made the phone call to South Sound 911, so there's no discovery violation. Any other questions from the defense?
So Conrad Shadle will be here at 10:15?
Yes.
Okay, I'd ask the permission to voir dire him outside of the jury.
Oh, that'd be granted. No. Actually, to be fairness, state your perspective on the permission to voir dire him outside the presence of the jury.
That's fine. Is that going to be before he testifies? Is that how I'm hearing that?
Well, no, theoretically, well, I'll let the defense argue its own motion.
Yes, outside of the presence of the jury,
Under oath,
under oath.
as an offer, well, yeah, to voir dire.
Correct.
Upon the offer of proof the state's made.
Correct.
Before the jury comes out, not after you question it.
Well, I assume the defense is going to want to do it before the jury would come out.
Yes.
Yes.
Just seeking clarification, that's fine.
All right, so what's anticipated is when Mr. Shadle arrives, he'll be placed under oath, the jury will not be present, and then the defense can voir dire him, and then, of course, if the state has any subsequent questions it wants to ask of Mr. Shadle while the jury's not here, the court would grant that opportunity as well.
Understood. Thank you, Your Honor.
Just make a record.
I want, just to further make our record on the 4.7 issue, the state interviewed Mr. Shadle and sent us their interview records from that, and nothing in that described his discussion about what kind of an entity South Sound 911 is. So I continue to disagree that they put us on notice that Mr. Shadle will be testifying to that topic.
No response.
Not being asked to say anything further, so I won't. Anything else from the defense
Nope.
on this motion?
No.
State?
No, Your Honor.
Is, we have the defense motion to dismiss count one, the false reporting allegation, and sufficiency of the evidence. I recognize there may be further testimony, so I'm going to leave it up to the defense whether it would rather argue that after the reopening occurs and any other evidence is brought in. I don't know if that testimony would be involved in the false reporting, but I can tell you I'm a little bit nervous. Things might come up that then you would want to, if I rule on the motion now, then something comes up, you'd want to revisit it. So, but I'll leave it up to the defense. It's your motion, so with respect to the motion to dismiss false reporting, the timing of it.
That motion is a motion primarily about proximate cause and a legal issue. I can't imagine Mr. Shadle's testimony will impact it, so I'm comfortable going forward with the motion now.
Is the state ready to respond to that?
Yes, Your Honor, but I think it's the same motion, isn't it?
Well, that,
I think they're just asking the court to change its ruling.
I actually, in looking at that, I didn't present it to counsel, but there's case law that would support a defense making a motion for insufficiency of the evidence after the state rests, making the motion after the case, all parties have rested. And so it's not an improper motion for the defense to make several times based on the case law I could find. Maybe the state has case law to the contrary. And what's changed is that the court has heard additional evidence, obviously in the state's case or the defense case, that it may want to highlight. So it's a little bit different motion, I think, than what was made after the state's case, because now the court would, as you all know, required to consider all of the evidence that's been testified in the case, both defense evidence and state's evidence, but of course relying upon looking at that evidence in the light most favorable to the state. So it's not entirely the same. It could be And maybe I'm just misreading what the case law says or what the defense wants, but at least I just wanted to share with you my research last night about this type of motion. And so I don't think it's improper to raise it now after the case is, after the testimony is all reserved or taken, but I'll leave it up to the state to argue. If there is case law saying if you raise it after the state rests, you can't raise it again, I'd want to hear that or see that, but the case law I looked at seemed to say to the contrary. Anything else, your state's perspective on that?
That's fine, Your Honor, thank you.
All right. So is the state ready to respond to the defense motion to dismiss count 2 after considering all the evidence that's been presented so far? I'm sorry, count 1?
I just want to be clear, it's the same argument about the proximate cause, correct?
Well, we'll see. I don't know that, but I mean that.
Well, I guess I'm ready to respond, but I haven't heard the argument to see if it's any different.
All right. Court will hear from the state after the defense. So with respect to the defense motion to dismiss count 1, Mr. Gross.
Thank you, Your Honor. Just as a brief table setter, what we are arguing is that the word cause in the false reporting statute means proximate cause. And proximate cause has two components, one of them being but-for cause, and that because the state was required to prove but-for cause in this case, they have failed to prove an essential element because they have failed to present any evidence that Sheriff Troyer knew that when he called 911, he was not likely to get an emergency response but for his allegedly false statements about threats to kill. And yesterday the court made a statement that I interpreted, and maybe I misheard this, that the fact that the word proximate cause did not appear in the statute itself meant that proximate cause was not, that proximate cause did not need to be proved. And I'd like to cite an additional case now, which is State v. Bauer, 180 Washington 2D 929. And Bauer is a case that analyzes the Assault 3 statute, and the Assault 3 statute has a number of ways that it can be committed, but one of the ways is that with criminal negligence, this is RCW 9A 36031, subsection D, with criminal negligence, a person is guilty of assault in the third degree if he or she, under circumstances not amounting to assault in the first or second degree, down to subsection D, with criminal negligence, causes bodily harm to another person by means of a weapon or other instrument or thing likely to produce harm. And so the word proximate cause does not appear in the statute. But what Bauer says is that our court has ruled, this is a quote, our court has ruled that before criminal liability is imposed, the conduct of the defendant must be both, 1, the actual cause, and 2, the legal or proximate cause of the result. And it holds that the word cause in this Assault 3 statute means proximate cause, approximate cause and actual cause. Now, it is true that the RCW for false reporting isn't I guess what would be a typical way of committing a crime, which is that a certain act causes a specific result, because false reporting statute does not require that the false report actually cause an emergency response. What it requires is that the defendant knows that such false report is likely to cause an emergency response. And what I understood the state to be arguing yesterday and the court to rule is that the word likely to, preceding the word cause, in some way changes the meaning of the word cause. And I looked and could find no authority that would suggest that. And I want to, but for cause, I think at a bare minimum is what cause means. But for cause is part of the civil cause language. I think but for cause, regardless of whether proximate cause is required, but for cause absolutely is required. I've never seen any criminal statute where the state was not required to prove but for cause. So the other thing is, Your Honor, I could find no case that suggested that the word likely to in any way modifies what the word cause means. And the word cause means proximate cause in no way renders this statute incomprehensible or absurd. I think it actually makes this statute make more sense, which is that a person is not found guilty of false reporting if they call a dispatcher with a legitimate reason for an emergency response, but in the course of making that 911 call, something that they say in it turns out to be false. Because if a person legitimately needs an emergency response, an emergency response is going to be sent anyways, we don't want to criminalize the person for making a false statement that didn't impact whether or not an emergency response would be sent. Finally, if there is any ambiguity about what the word cause means in this statute, the rule of lenity applies, because Mr. Troyer did not write this statute, and any ambiguity in what a criminal statute's language means is interpreted in favor of the defendant. So for those reasons, Your Honor, I'd ask the court to find that the state was required to prove that Mr. Troyer knew that when he made his allegedly false report, he knew that without making a false statement, he was unlikely to get an emergency response. And I also rely on my argument yesterday and my briefing on the subject.
Briefly, Your Honor, I don't think there's been any different argument presented today than when the court initially rejected this. The statement or the language here is likely to cause. You cannot read cause without likely to cause, and likely to cause is a mens rea element. This is not a physical connection between an act and an injury. And there is no rule of lenity application here because there is no ambiguity, because the legislature expressly, when they elevated section 2A and B to felonies, indicated specifically a proximate cause element. That is expressly not in the gross misdemeanor version of this, so causation was specifically excluded by the legislature. Likely to cause is a mens rea element of which there is plenty of evidence.
Likely to cause is not the mens rea element. That mens rea element is knowing. And I still am not clear why there would be a distinction. I mean, cause has to mean something. And I don't know what the state is suggesting it means. The word cause has been, litigated probably since the beginning of time what that means. There's an incredible amount of case law out there about what the word cause means, and it has a legal meaning. And it can't go undefined because it has a legal meaning. And I don't know what the state is suggesting the legal meaning is.
I want to take a chance to read the Power case, so I'll briefly reserve my ruling on this until I get a chance to read the new case that the defense cited. I think it's important that I look at that case. And will. The parties ready at this time to talk about your instructions?
Yes.
No, Your Honor, because I think it depends on this court's motion to dismiss ruling.
And that I understand, but generally can we go through, my preference would be to go through the instructions the state has presented.
Yes.
And when I do that, it'd be my preference to just start with each instruction the state has and identify it, and then have the defense indicate whether they have objections to it or not. Go ahead.
That sounds good, Your Honor. We just haven't sent out our proposed instructions yet, so we'll circulate that now.
Okay.
Yeah, I sent you notes, but for the name.
Do you have copies for the court?
I'm sorry, Your Honor, we don't have paper copies.
Okay.
Apologies.
Or
I
Dan.
can send them.
The reason is because I expected that this motion be ruled on, and then we would finalize our jury instructions.
Well, at this point, what the court, the reason for bringing it up now is if there's agreement on instructions, it makes sense to know those. If there's disagreement, well, then there's going to be additional time for the parties to argue about that, and that's why the court just prefers going through well, at this point, we could go through the state's instructions, and I'll first ask the defense what your position is. If there's no agreement, okay, then I won't deal with that again, that's fine. If there is, I'll make a note, and then we'll talk about it later, because I don't want to, I'm not going to require the defense to right now say, here's my objection, et cetera. After the instructions are, I've decided which ones to give, times for exceptions to the instructions will certainly be permitted, but on instructions that you disagree with, I'll put those aside because I just as soon hear argument about all those after we decide the ones that there is no disagreement on, and I suspect there's probably plenty there is no disagreement on. The packet looks like a General Whippick packet on a lot of it, so let's go ahead and, while the defense is pulling up its instructions, and we can certainly assist with printing, I think. So let's go through what the state has proposed in the state's instructions. Are you, defense, ready? Do you have those?
Yes, Your Honor.
State, are you ready?
Yes, Your Honor.
All right, so the first instruction the state proposed is the Whippick 102, the introductory instruction. Any comment from the defense?
No comment.
The next instruction is the Whippick 301, separate charge.
We'll reserve argument on this one.
Oh, yes, that's right. Next is Whippick 501, circumstantial direct evidence.
No comment on this.
Next is Whippick 401, not guilty plea, presumption of innocence and reasonable doubt.
We do object to this one and have a proposed one of our own.
Have an alternate one.
Yes.
Next is Whippick 6.31, since the defense testified, I assume the state's going to withdraw that. All right. Any objection to withdrawing that?
No.
Next is Whippick 6.41, out-of-court statements by the defendant.
We object to this one.
State?
It's just a general whipping. And
If
I
the
don't see why they would object to this.
It's the court's understanding with this one, this is more, the court should lean on a defense preference, whether to give this or not, because it may highlight things the defense wouldn't want to have highlighted. On the flip side, the defense may want to have this, so let me ask this, would the defense have, or would the state have an exception if the court did not give Whippick 6.41?
Yes.
Okay. Next is Whippick 126.15, definition of false reporting. Defense?
One moment, Your Honor. We are going to be proposing our own and objecting to the state's.
Alternate. Next is RCW 9A 840405A, definition of emergency response.
No comment.
Next is Davison versus State, citation to cities and counties are political subdivisions of the state.
If I could have one moment,
Sure.
I meant to look at this case and I just forgot. No comment.
Next is a to convict instruction.
We do take exception to this and we'll have our own proposed one.
Whippick 12003, concerning a definition of false misleading statements.
No comment.
Definition of public servant under WIPIC 2.22.
We take exception to this and we'll propose our own.
WIPIC 2.11, government.
No comment.
WIPIC 2.12, government function.
We'll be moving to strike this one.
Will there be an alternate or just move to strike?
No alternate.
WIPIC 120.04.01, material statement definition.
No comment.
WIPIC 10.02, definition of knowing or knowledge.
We take exception with this and we'll be proposing our own. I worry that I actually am looking at something different than this court, because I have, after material statement instruction, the to convict instruction, and then the knowingly instruction.
I may have rearranged that. My preference is normally to put the elements in the to convict. So that's not, you're looking, I suspect you're looking at,
The same thing, yeah.
I think that's true, because I remember I did do this when I was reviewing these, so.
Okay.
It would have been after the to convict is the WIPIC 10.02.
Okay, to ensure that we're all on the same page, after we've finalized them, I'd like a chance to review them before they're completely finalized, to make sure that we've been looking at the same one.
Of course.
Okay.
WIPIC 120.04, to convict for.
No comment.
WIPIC 151, the concluding instruction.
No comment.
WIPIC 1.04, duty to discuss.
No comment.
I will say on this one, it's likely I'm going to put this close to the beginning. That's just my preference to have that probably either before or after the definitions of presumption of innocence, et cetera. To put that early on, the jurors know this, but that's my general practice unless I hear contrary. The verdict form for count 1,
No comment.
verdict form for count 2.
No comment.
Thank you for taking the time to go through those preliminarily. That's helpful.
And we've circulated our proposed.
Has the state seen the defense proposed, or is this the first time?
Just got an email.
Jared,
Okay. We're having copies printed for council.
Jerry, do you on Twitter about these arguments? Not yet. I mean, it's just.
Anything else from the defense at this point? Contemplating taking a recess so I can look at that case you cited, and then we'll see whether the witness is ready, and then come back 15 minutes or so.
That's fine with defense.
Steve?
Thank you, Your Honor, I'll have some coffee. That'd be great, thank you.
All right. So this time the court's going to take a recess. I'll have rather than saying the 15 minutes, because depending upon when the witness is here or not and you're ready to go, I'll just if the parties would let the clerk know when you're ready to go, then actually I'm going to stay on the bench and do the research here, but we'll be at recess, and then we'll come back when the parties are ready. Court's at recess.
Thank you, Your Honor.
seated. The court did have a chance to review the Bauer case that was cited by the defense concerning its motion to dismiss count one, the false reporting charge. And so was there anything else the defense wants to present on its motion?
No more authority.
Okay. Oh, any more argument?
No, I'll just be repeating myself, so rely on my earlier argument.
All right. State?
Your Honor, no, we haven't had a chance to read it, but no more argument from the state.
So as I indicated before, and similar to counsel, I'm not going to repeat what I said before on the motion to dismiss that the state raised concerning count one after that the defense raised concerning count one after the state rested. All of those findings that the court made remain the same, so I'm not going to repeat those. I've already said those with respect to the facts taken in light most favorable to the state. This issue about Bauer, the court had a chance to read it. It was the Supreme Court was construing the Assault 3 statute, and the defense is right. There's a lot of alternate means of committing Assault 3, and the one that the Bauer focused on was criminal negligence. And that was important in the Bauer case because there was no mens rea with respect to the causation. With criminal negligence, you did something that hurt somebody. And so Bauer, the Supreme Court said, well, in comparing it with tort law, where you do an act that results in something, there may or may not necessarily in tort law be required a mens rea to show that you intended the result that your actions caused. And so the Supreme Court said in criminal law and discussed the history of criminal law that to impose criminal liability on somebody based upon criminal negligence without any mens rea is something the court was very concerned about, especially when it was you did an act which caused some harm to occur. And so the Supreme Court held that the way to protect a defendant from that is to incorporate the phrase proximate cause rather than just caused a harm. And by proximate cause, then the defense would be able to get into potentially superseding causes or, in fact, be able to use the but-for analysis that Mr. Gross accurately discussed with respect to what proximate cause means. So that's the Bauer case. The Bauer case is also cited concerning vehicular homicide, where a person does some act. Let's use one example where a person's impaired by a substance or alcohol, and then drove, and that driving caused the result of a death in vehicular homicide or caused serious bodily injury with respect to vehicular assault. The statute in vehicular homicide includes proximate cause in the definition of the crime, so logically proximate cause would be something the state has to prove. Vehicular assault, however, does not include the phrase proximate cause. It includes the phrase cause, and the appellate courts have ruled that given the statutory requirement of proximate cause in vehicular homicide, the state was going to have to prove proximate cause for injuries that were caused in vehicular assault as well. And so that's an example of which the defense would argue is the word says cause in a statute, but the appellate court said no, cause means proximate cause. Again, vehicular assault and vehicular homicide don't require a mens rea, and so that is, I think, a factor in at least with respect to vehicular assault. In looking at malicious mischief, as the parties know, there are many statutes which say you do some act, usually there's mens rea involved, that causes a result. Arson would be like that. Reckless burning would be like that, where you set a fire, but then that causes damage to property, et cetera. And the statute, the legislature uses the word cause with respect to the mens rea. You knowingly created the fire or recklessly, but then caused it. And so looking at the malicious mischief statute, it's very similar. And one method of committing malicious mischief in the first degree is when a person knowingly and maliciously causes physical damage. And when you look at the to convict instruction and the comments under malicious mischief, the knowing and malicious is an mens rea, but the cause is not a proximate cause, and the statute doesn't require proximate cause, nor does the WIPICs with respect to what the state has to prove require a proximate cause, which would potentially open up the idea of superseding intervening causes as well. And this malicious mischief statute's old, there's been a lot of litigation on it, and so that's an example of where the legislature uses the word cause with a mens rea criminal statute, and at least with respect to malicious mischief, there has been no incorporation of cause to mean proximate cause, which is something the state has to prove. And we've talked about this before. I'm not surprised with respect to the false reporting. We've not had a case on point. You know, does that mean the defense should be, the motion should be granted or no? Well, no. If there's no authority, there's no authority. I'm not sure that really cuts against either side. But the Bowers case is dealing with crimes with lacking mens rea. Vehicular homicide and assault are crimes lacking mens rea. False reporting does not lack mens rea. In fact, it has a knowing element, not intent, but has a knowing element to it. And using malicious mischief as a similar type of crime and analogizing malicious mischief and the requirement in that case that proximate cause need not be proven of the harm, the court is going to deny the defense motion to dismiss count 1 and find that there is no statutory or at this point case law requirement that the state has to prove that the knowing contacting, the knowing initiating of an allegedly false report requires the state to prove that the actor who knowingly initiated the false report was likely to proximate cause an emergency response. And so for that reason, the defense motion on count 1 is denied. I do have to say that it caused me to think quite a bit about the general idea of criminal law and what should the state have to prove when the legislature uses the word cause. And certainly from what the defense is arguing, I very much understand why the defense thinks that that should be a burden on the state, and then why the defense has a response if in fact proximate cause is required under the false reporting statute. So this is a significant issue the defense has raised, and it certainly caused me to think about what the proper response should be with respect to, I would incorporate proximate cause into the legislative definition of cause. And it will be subject potentially to future litigation on appeal, I suspect, as to whether the defense is right with respect to the false reporting statute, but that's the basis for the court's denial of the defense motion to dismiss count 1.
Your Honor, can I briefly respond?
Of course.
The court cited the malicious mischief statute as an example of a statute and a WIPIC, neither of which require proximate cause, but the same could be said about Assault 3. Neither the Assault 3 statute nor the Assault 3 WIPIC mention proximate cause. And so the fact that the malicious mischief statute does not say anything about requiring proximate cause does not mean proximate cause is not required.
I would say Bauer specifically focused on the malicious, or on the negligence aspect, that an actor's negligence caused, in this case proximately caused, injury under the assault statute. The remaining methods of committing assault in the third degree involve intent, so that's a mens rea crime with respect to the other. You intend to commit an assault that then does harm, and so there's mens rea, other than in the negligent assault that defense cited in the Bauer case. That I think that's a distinguishing factor, and I'm not aware that, well, and so that's the I understand what the defense is saying, but the court holds that Bauer is distinguishable because it was dealing with a crime that had no mens rea, and false reporting does.
So I guess, Your Honor, I'll fall back to my argument regarding the rule of lenity, because it sounds like what this court is saying is that the word cause is ambiguous in this statute. It's not defined by the statute itself, and the case law hasn't, the court hasn't, and neither has the state found case law that suggests that cause in this circumstance means something different than proximate cause. Under the rule of lenity, when there's ambiguity in what the language of a statute means, it must be interpreted in favor of the defendant.
I agree with your analysis about the rule of lenity, but the court finds that proximate cause is not the definition of cause, so there is no ambiguity in the statute. The state has to prove that the false reporting was likely to cause an emergency response, and there's no ambiguity because the court does not incorporate proximate cause as a definition of cause.
My only response to that is that it is well understood that the word cause has various meanings, various legal meanings, and that, it can mean the substantial factor test, it can mean the but-for cause test, it can mean the cause and fact test. There's all kinds of meaning for the word cause. And so the word cause by itself, without reference to exactly which of those tests apply, is ambiguous.
In this statute, it says likely to cause, and so I think that's a distinguishing factor. Counsel could be right, but I'm not persuaded.
Thank you, Your Honor.
Your Honor, the witness is here.
Just going to ask about that. Is the state ready to proceed with the witness?
No, I haven't.
Your Honor, defense is the one that requested to voir dire the witness, so we'd asked to.
Oh,
voir dire the
correct.
witness.
Are you ready to voir dire?
I'm ready.
Thank you for reminding me about that. Is the state ready?
Yes, Your Honor.
Could you please bring in the witness?
Here.
Could you do that?
Yeah.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, please. State your name and spell your last name.
Conrad Shadel, Shadel.
Mr. Gross.
Thank you, Your Honor. Good morning, Mr. Shadel. You work for South Sound 911, right?
Yes, sir.
Who issues you paychecks?
South Sound 911 through taxpayer money.
Yeah, my question is, who issues you paychecks,
South Sound 911.
right?
Mhm.
South Sound 911.
Yep.
You're not a county employee.
No.
You're not a city employee.
Correct.
You're not a district employee.
No.
You're not a state employee.
No.
Okay, Your Honor, I'm going to object to the leading questions. This is voir dire. He needs to ask open-ended questions.
Court will give some leeway. Overruled.
Do you have any legal training?
Any legal training? No, I do not.
Do you have any legal education?
No, I do not.
Do you have any legal experience?
I do not. No.
Do you have any education or expertise in corporate forms?
Say that again.
Corporate forms? Forms of corporations?
No, I do not.
Do you have any legal expertise in government forms?
I do not.
Do you have any legal expertise in any kind of company forms whatsoever?
No, I do not.
Starting from yesterday, when was the first time you were contacted by the Attorney General?
About 6 p.m. yesterday, I got a call just saying that they needed me to come back to court.
Who called you?
Melanie Tretnick.
And was that on the phone?
Yes, correct.
And did you have a conversation about her with her about what your testimony would be?
Before coming up here today, yes, briefly.
What did Ms. Tratnick tell you?
She stated there were some questions about my role as a public servant.
Okay. Did she give you any information?
She just asked me questions about being a government employee.
Okay. Did she give you any information about South Sound 911's legal status?
No, no.
And when was the next time you talked to someone from the Attorney General's office?
So yesterday she called me. I didn't answer because I was at work. Texted back, said they needed me in. So then I just texted and said I could come in at 10:15 when they were asking. And then today when I came into the court building, and we had a meeting. But that's the only contact we've had.
The second time you talked to either Ms. Tratnick, Ms. Serrano, or anyone from the Attorney General's office was this morning,
Yes, correct.
when you came into the building?
Yes, correct.
Where did you meet with them?
Second floor, just by the entrance.
Who was a part of that meeting?
Barb and Melanie.
And how long did that meeting last?
I honestly don't know what time it is, so maybe 10, 15 minutes or so.
And did they tell you what they wanted you to testify to?
No, they were asking me questions about whether I was a government employee and basically wanting to know my answers.
Did they give you any information about South Sound 911's legal status?
They did not know.
Do you know what the legal entity status is of South Sound 911?
I do, yes.
What is that?
It is a public authority.
How do you know that?
I kind of am aware of this because I worked on a committee. We don't contribute to Social Security, and I kind of headed up that committee. When we transitioned from interlocal agreement to a public authority, we decided to opt out of Social Security. And so I was made aware of its status and a little bit about what that means.
What does it mean?
That it's a intergovernmental agency that's formed and has a board, a representative of elected officials. That's pretty much as far as I understand.
Do you know whether it's part of any specific branch of government?
I'm not aware of that.
Do you know whether it's part of any specific unit of government?
I can't speak to that.
Do you know whether it's part of any specific division of government?
I can't speak to that.
So when you say that you're part of a committee, what was the name of that committee?
Social Security Advisory Committee, I believe is what we called it.
What years were you on that committee?
It was during the time when South Sound was transitioning from interlocal to the public authority it is now. So 2019 maybe? Honestly, I don't totally recall. And it was maybe 8 months or so, 6-8 months.
Did that committee have anything to do with the decision to change forms?
No, this was a reaction to that change.
What was your role on that committee?
I was the employee lead representative, would probably be the best way to describe it.
Who told you while you were on the committee that the Social Security, that the form of the government, the form of governance of South Sound 911 was changing?
The director had put that information out prior. It's public knowledge. It's available, I'm sure, on our website under public archives.
My question is, who told you the government form?
The director at the time, I'm sorry, I'm blanking on his name. It's not the current director any longer. Andrew Neiditz, there we go.
Andrew what?
Neiditz?
Neiditz?
Yes, he's since retired.
Did Andrew Neiditz tell you what the change in form of governance meant?
There was details about that, something about how I think there originally was sort of 2 boards, and then that was changing to 1. My understanding it was just a reorganization for simplicity of management.
Were you in any way part of that information was provided by Andrew Neiditz?
Yes, correct.
Were you part of, in any way, of the decision to change form of governance?
No.
Have you ever reviewed any paperwork associated with the South Sound 911's form of governance?
I believe that public authority document was made public in the board meeting notes, and I'm sure I read it at some point, but I don't really recall exactly what's in it.
So you're saying that you have read the paperwork associated with the change in the form of governance?
Yeah,
South Sound 911?
Yeah, it's part of it was a part of the board meeting notes, I'm 99% sure. That they put out every month, they have like the meeting minutes and stuff, and they post any documents, budgetary and that kind of stuff in there. I like to keep up on stuff.
What was the title of that document?
It would have just been the board meeting minutes from, again, I apologize on the year, probably, it would have had to been, I think, 2019, but honestly, I can't recall. Might have been 2018.
Are you describing reviewing meeting minutes or the document, the actual document, like the legal documents?
So the meeting minutes will then have after what was reviewed during the meeting, they'll have all the relevant documents from that meeting attached to it. So it's usually one large, sometimes 50-page PDF or something like that.
And you're saying that you reviewed the actual legal document that changed the governance?
I'm pretty sure, yes.
What was that document called?
I don't know.
What did the document say?
It was just noting that there was a change between, or from being an interlocal agreement to a public authority.
And what did the document say that meant?
I don't know that it did, other than that change was happening.
Aside from Andrew Neiditz, where else have you received, in the document you just described, where else have you received information about what type of entity South Sound 911 is?
Other than in certain places it's listed that it's like South Sound 911 Public Authority, on some of our like training materials and stuff like that, I can't think of anything else that sticks out.
And South Sound 911 has a board of directors
Yes, correct.
and an executive director.
Yes, correct.
Do you know whether South Sound 911 is a limited liability entity?
Not to my understanding.
Sorry, you don't think it is, or you don't know?
My understanding on an LLC is that that's something you would, if I'm opening a business on the corner or something. So as far as I know, it's not an LLC, no.
Well, I'm not asking about an LLC, but is it a limited, is it an
Oh, gotcha.
entity that has liability limitations?
I genuinely don't know. You'd have to ask our attorney.
Do you know whether South Sound 911 can be sued directly?
I believe so, yes.
Do you know whether South Sound 911 can sue others?
That I don't know.
Do you know whether South Sound 911 is an independent contractor?
Yeah, I'm going to object to this line of questioning at this point. It's gone far afield from the purpose of this board here.
How so?
I'll withdraw the objection.
All right, you may continue.
One moment.
Just take one. Just take it. Go, here. So just go ahead and look at my phone. But, okay, we've got two.
Do you know whether South Sound 911 is part of any specific branch of government?
I don't know. I don't know how to relate that, specifically to the organization.
So the answer to that question is no.
Correct.
You know the purpose for which South Sound 911 was formed?
My understanding is that it was formed to improve the 911 capabilities of the county for police response and fire response.
Where did you get that information?
Just from past discussions about why it was formed. I don't think I was not an employee when the initial formation of the interlocal agreement happened, but I was an employee of an agency that was pulled into South Sound 911, if that makes sense. Because not all the agencies signed at the same time. It was kind of this progressive change.
Do you know whether South Sound 911 is part of any particular jurisdiction at all?
I really can't speak to that. No.
Do you know whether South Sound 911 is governmental or quasi-governmental?
I honestly don't know how to answer that. I would assume governmental, but again, I'm not a lawyer, so I don't know.
You don't know.
No.
Do you know whether South Sound 911 operates under any policies of any particular jurisdiction?
We operate under policies that are given to us by all the police chiefs in the county and the sheriff.
In the county?
Yes, correct, in the county.
Sorry. My question is, do you as an employee, let's say, do you have a handbook, an employee handbook?
I understand now. Yes, we do have a handbook, and it's derived from our own policies.
From South Sound 911?
Correct, yes.
You don't follow, as an employee, the employee handbook of any particular jurisdiction?
Correct.
Does South Sound 911 bill out to individual jurisdictions that it works for?
Yes, it does.
We have one from her. This one? How about that?
Does South Sound have a contract with, for example, Pierce County?
Yes.
Does South Sound contract with every entity that it provides services for?
I couldn't answer that for sure.
Are you aware of any entity which South Sound provides services for that it does not contract for?
Not that I'm aware of, no.
How many agencies do you contract with?
It's, I believe, 17 or 18 law enforcement agencies, but then there's, I don't know how many fire entities, a lot. I think in the 30s.
30 fire entities.
somewhere around there. I don't do anything related to fire, so I'm not aware.
Are the jurisdictions that South Sound contracts with all within Pierce County?
Yes, except for one, which is an animal control agency that services Pacific and one other outside I can't think of right now.
Did you testify in this trial that you were a county employee?
I don't recall.
Well, if you had testified to that, would that be true?
I don't believe so, no.
No further questions.
Hey. Hello. Mr. Shadle, did you work last night?
I did, yes.
Okay, and when did you get off?
5 a.m.
Appreciate you coming back in. You testified that South Sound 911 was created as a, public authority, correct?
Created as an interlocal agreement and then transitioned to a public authority, yes.
Okay, and who belongs to that public authority?
When you say who belongs, are you talking about, I'm sorry.
Which entities?
Sorry. So South Sound 911, but are you talking about the agencies that we contract with?
I'm asking what agencies are part of the public authority?
Gotcha. South Sound 911.
Yes.
Okay.
What agencies are part of South Sound 911?
I'm
I'm sorry.
sorry,
let me
I'm
ask
not,
you a different question.
sure.
I'll get right to the point. Is South Sound 911 a government entity?
That is my understanding, yes.
And are you an employee of that entity?
Yes, I am.
You testified earlier that you were paid through taxpayer money, correct?
Yes.
Why did you say that?
Because I think that quantifies that it's a government agency, but again, I'm not a lawyer, so.
And how do you know that your money, how do you know that your paycheck is coming from taxpayers?
Because as I mentioned before, I like to look at board documents, and the budget clearly states that.
Do you receive any benefits through your employment?
I do, yes.
Okay, what kind of benefits do you receive?
We're part of the PERS, Public Employee Retirement System pension, and they offer other assortment of retirement accounts available for personal investment.
Okay, and who administer, and PERS is P-E-R-S, correct?
Yeah,
And who administers PERS?
the state.
Mr. Shadle, what did you mean when you said that you operate under the policies given to you by the county police chiefs? Can you explain that, please?
Sure. We have I don't believe it's a board any longer, maybe operations committee, I think it's called now. And it consists of different police chiefs and I'm pretty sure a representative from the sheriff's department who dictate our policies on how we handle 911 calls.
That's all. Thank you, Mr. Shadle.
Okay.
Do Do you know whether you have to be a government employee to be part of the PERS program?
I'm not aware.
If I told you you could be an independent contractor working for the government and still be part of the PERS plan, would you have any reason?
Objection, we're part of PERS, that is an incorrect legal statement.
Sustained, but you may rephrase the question.
Well, I'm looking at the Department of Retirement Services website for PERS. And if I was to read you a statement from this website that says that independent contractors could be part of the PERS plan, would you have any reason to disagree with that?
Your Honor, he can't read from a website, and that is misleading. He can ask him what he knows, but that is simply not correct.
Overruled. He can answer, well, he may answer if he's able.
Would you have any reason to believe that independent contractors who are not government employees can be part of the PERS plan?
Based on what you're seeing there, no.
So, based on anything, do you have any reason besides to disagree with that statement?
No, I don't have any reason to.
Did you say that you do not pay into Social Security?
That's correct.
Do you know whether people that are government employees are required to pay into Social Security?
My understanding on that is that when you are a part of a program like PERS, then the federal government allows you the option to not participate in Social Security because you're already participating in a retirement pension program. Does that answer what your question?
Do you know, I guess for yes or no, do you
Oh.
know whether people that are government employees are required to pay into Social Security?
I don't believe they are,
And how do you know that?
because of my time on the committee that I mentioned.
You said that the source of your information that your paycheck comes from taxpayers is by reading a budget.
Yes, correct.
And that's a South Sound 911 budget.
Yes, correct.
Do you know whether South Sound 911 meets the legal definition of a government entity?
I do not know.
No further questions.
State.
No more questions, thank you.
You may step down. Do not discuss your testimony with anyone other than the attorneys, and I'll have you wait in the hallway.
This doorway or the main hall?
State your preference as to where the witness remains. Not in the courtroom, but where.
No.
Okay.
Anywhere.
They had me out there before, sir. So I was, okay.
Oh, right.
Next step is this.
State.
We're looking at WAC 415-02-1110. I'll give everybody a minute to get on that. Subsection 1, an employee of a retirement system employer other than a teacher's retirement system plan, 1, retiree, who otherwise meets the eligibility criteria to participate in a state-administered retirement system is required to establish or continue membership in that system. An independent contractor is not eligible for active membership in any state-administered retirement system, which is PERS. PERS is the Public Employees Retirement System, and as this WAC illustrates, I don't know what they were looking on the website, you can't be a part of PERS unless you're a state employee.
What agency
Now-
promulgated that whack?
What agency promulgated the WAC? I'm gonna have Ms. Serrano look that up while I keep reading here. Your Honor, the question that I asked him is South Sino 911 a government entity? And he said, yes. And I asked him if he was an employee of that government entity, and he said, yes. He also explained that he gets paid by taxpayer money, and I'm not aware of any private company where the employees get paid by taxpayer money, gets paid by taxpayer money. And that's all that we're required to show here, which is enough information for the jury to conclude that he's a government employee, which he is in the best position to know, and he's testifying very clearly that he is. That South Sound 911 is a government entity, and he's an employee of that, and he gets paid by taxpayer money. And additionally, he's part of a state system that he wouldn't have pension access to if he wasn't a government employee. And the state has offered WIPIC 2.22, that's not the one I want. Yes, WIPIC 2.22, public servant means any officer or employee of government. And sorry, you're all right. Oh, here we go. And then also WIPIC 2.11, government includes any branch, subdivision, or agency of the government of the state and any county, city, district, or other local government unit. There's sufficient evidence for the jury to conclude, without this expert legal analysis of LLCs and whatever those other questions were, that he is in fact an employee of government. He gets paid by the government, he works for a government entity, he gets pension benefits from the government. That is sufficient evidence.
Isn't it true that if the court bought a pen at Staples, a private company, Staples would be paid with public money to buy the pen?
I'm
Yeah,
not-
you stated that you're not aware of any private entity that is paid by public money, and the court contracts with all sorts of public entities, like even Staples, to buy a pen. And they would be paid, Staples would be paid with taxpayer money, since it would come from the court's budget, which is taxpayer money, that would go to Staples. So I'm not sure I understand your distinction with respect to that no public monies would be paid to a private company.
You're right. The example that you're giving is a customer purchasing something from a private entity and using government money. What I'm saying is that this government employee is being paid through taxpayer money. That's different than a customer buying something from a private company and then that company receiving money from the customer, which paid with the taxpayer money. I don't think the analogy fits at all. He's paid, nobody's purchasing anything from this employee. He is paid directly by taxpayers. That makes him a government employee. Nobody else gets paid with taxpayer money.
Well, except for it sounds like from what his testimony is, that he is paid from South Sound 911, and South Sound 911 obtains money, taxpayer money, to pay him. So that would be like paying Staples taxpayer money, who then uses that money to pay the employee, wouldn't it?
But Your Honor, South Sound 911 isn't getting its taxpayer money from people purchasing anything from it.
Well, they're purchasing.
The entity is funded with taxpayer money.
Isn't what's being purchased 911 services?
No, it is a government entity that is funded by taxpayer money that he works for. I asked him if this is a government entity, and he said it is. And he gets paid through this government entity. His employer uses taxpayer money to pay him.
Okay. Anything else?
No, Your Honor, thank you.
Defense.
All right, I'll start where we left off, which is they asked him directly, do you know whether South Sound 911 meets the legal definition of a government entity? And he said no. I think what is clear from the questioning of both parties, is that this is a very complicated issue, where what South Sound 911 is, where it fits, whether it's a branch of government, if it is, what does that mean? He said repeatedly, I think this, but I don't know, I'm not a lawyer. And all of the information he has about what South Sound 911 is not from his personal knowledge, it's from hearsay. He described getting information from a person about what it means. He described reading it in a document. He described reading a budget to determine that South Sound 911 gets money from taxpayers. All of that is hearsay. He has no legal training. He has no legal expertise. He has no experience in corporate forms or government forms. What he knows is what he's heard and what he's read. And that's all hearsay, and it's not within his personal knowledge. As far as, the analogy to Staples, okay, so maybe that's not an example of an entity the taxpayers pay that is sort of like a full company. It's them purchasing. But our firm was working on a case now that supported living company, which is a private company, receives $40 million a year in government funding to administer services for the government. So, and there are road crews that the taxpayers pay private companies to clean the roads. I mean, there's all kinds of examples of private companies. The KLB case is a perfect example. Securitas is a private company the taxpayers pay for. So the fact that the taxpayers are the ones that end up footing the bill for him doesn't mean that they're a government entity. He said it directly, the very last question. He does not know whether South Sound 911 is a government entity. I think to bring him back to testify to this would absolutely confuse the jurors, because this person doesn't know. It's from hearsay, it's what he kind of understands is going on, but he doesn't have any direct knowledge, he doesn't have any personal knowledge. And frankly, I'm not clear where South Sound 911 sits after talking to him. So I'd ask the court to deny the state's motion to reopen its case.
How would anyone know whether they're a form of government? For example, how would the court know that it is a member of a branch of government?
Well,
It would read the Constitution, theoretically, right? But wouldn't the Constitution be hearsay? Or wouldn't it be a document that would not be, wouldn't my knowledge of knowing that I'm a member of a branch of government be from what I would have read from the Constitution and or statutes?
potentially. I think
That's why, how would anybody know whether they were a member of a government entity or South Sound 911 if it is a government entity? How would one learn that other than through hearsay documents that would be outside the court?
two ways. I think one, in almost every situation, it's self-evident. Pierce County Department of Public Defense, that's a government entity. It's a department of the government. It's self-evident. Other way, and in a case that's more complicated than that, and in this case far more complicated than that, is by a legal expert. And a legal expert can testify to hearsay if it's within the type of documents or the type of information that an expert in the field relies on. So that is what the state should have done in this case, has not. Mr. Shadle is not qualified, has no personal knowledge, and it's hearsay. He's not qualified to testify about this, which is what we argued at the beginning.
State?
Your Honor, I asked him directly, is South Sound 911 a government entity? And he said yes. And then I asked him, are you an employee of that government entity? And he said yes. Now, the defense can certainly cross-examine him on the basis of his knowledge and then argue in closing that Mr. Shadle doesn't know what he's talking about, but his testimony will be that he is an employee of a government entity, and they can cross him on that, and they can argue in closing that that element hasn't been met. But he should be able to testify to his own personal knowledge of how he's employed. That's all the state is asking.
Last thing, Your Honor. The information that the state is seeking to get across to this jury is that South Sound 911 is a government entity. And I don't see how this court can let a lay witness testify to that information when the last question he was asked is whether he knows whether South Sound 911 meets the legal definition of a government entity, and he said no. And the state had an opportunity to clarify that or ask him questions to, try to rehabilitate that, and they declined to do so. So I'd ask the court to deny their motion to reopen the case.
That's a weight, not admissibility argument. He can testify to his personal knowledge, and they can cross-examine him on that, and then argue how they wish in closing that the state's testimony didn't meet the burden. But his testimony is admissible.
Your motion, so your last word to the defense.
Nothing further.
The issue presented concerns the definition of public servant under RCW 9A.04.11023. And a public servant is one who occupies, under the definition in the statute, is one who occupies the position of or has been elected, appointed, or designated to become any officer or employee of government. So the phrase is employee of government is what this issue resolves around. This individual has testified that he is an employee of South Sound 911, and his belief is that because he receives taxpayer money, that he is an employee of government and then provides government services, as has been discussed. The court, that is sufficient for the state to reopen the case to present this evidence. And the court agrees with the state that the concerns that have been raised by the defense are ones of weight, not admissibility. Court does not agree with the defense that the state would have to call an attorney to testify about the legal status of this when we have statutes that are in play that the court can read, the parties can read. And his testimony was that he, based upon his knowledge of his entity, is that it's a public authority. That seems similar to like the health district, where the legislature's authorized government to work with city and county governments to work together to create a health district and then gives the health district power. A health district is a public agency, but it's outside of what would typically be thought of as county government. It's broader than that. I think the transit in Seattle with respect to the light rail is an example of an entity that's government that was created that may serve various other entities. And so that is also a public authority that the government gives. The defense cited the statute about the public authority aspect of this, and so there is sufficient evidence that the state's seeking to elicit that would show that South Sound 911 is a public authority, which would make it government. And if this person, not if, this person is going to testify that he works for that agency, it's a public authority, then he would be an employee of government. So that's sufficient to at least allow the state to reopen and allow the testimony to be heard. And then any cross with respect to whether that should be relied upon or not by defense.
And Your Honor, thank you. Would it be possible to do that before noon, given that he's been up all night?
Defense?
No objection.
Agreed. Ready to call him? Because we'll bring the jury back first.
Yeah, I'd like to get him
Fine.
back.
If you would please bring the jury back into the courtroom.
You should do it for him. The one question.
So to be clear, the court has Granted, the state's motion to reopen as has been presented, the court has still reserved the motion to dismiss on count 2 by the defense. We'll deal with that after this witness testifies. The jury is returning to the courtroom. Thank you. Everyone may be seated. And good morning to members of the jury. The state's motion is granted. The state may call its next witness.
Thank you, Your Honor. I believe it'll be Mr. Shadle.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Have a seat.
Thank you.
State your name and spell your last name.
Conrad Shadel, S-H-A-D-E-L.
Ms. Stratnick.
Thank you, Your Honor. Thank you, Mr. Shadle, for coming back. Did you work last night?
I did, yes.
And when did you get off?
5 a.m.
Thank you for coming back. Mr. Shadle, how was South Sound 911 created?
As an interlocal agreement and then transitioned
Sustained as to the form of the question.
Do you know how South Sound 911 was created?
as an interlocal agreement and then
Objection,
transitioned.
foundation.
Sustained.
You have to answer yes or no first.
Sorry.
I know you're tired, I'm sorry. Do you know how South Sound 911 was created?
I do, yes.
And how was South Sound 911 created?
Objection, foundation.
Overruled.
As an interlocal agreement, which then transitioned to a public authority.
Is South Sound 911 a government entity?
That's my understanding, yes.
Are you an employee of that government entity?
I am, yes.
And how is it that you're paid?
Through South Sound 911.
And where does that money come from?
Objection, foundation.
Overruled. He may answer if he knows.
Objection calls for hearsay.
Overruled.
My understanding from reviewing the South Sound 911 budget, we are paid through contracts with contracting agencies, law enforcement agencies, fire agencies. We also receive direct tax revenue from the 911 tax that you see on your cell phone, as well as other services like fingerprinting and firearms permitting and things like that.
And do you receive pension benefits as part of your employment?
I do, yes.
And what is your pension benefit?
It's through PERS,
And what does that stand for?
the Public Employees Retirement System.
And who administers that pension?
My understanding is that the state administers it.
Nothing further, thank you.
Cross-examination.
Hello, Mr. Shadle.
Look,
South Sound 911 is not part of the state government, right?
that's correct.
It's not part of the county government.
As far as I know, no.
It's not part of the district government.
No.
It's not part of any municipal government.
No.
It's not part of any jurisdiction, as far as you know.
As far as I know, yeah.
South Sound 911 is run by a board of directors.
That's correct.
And has an executive director that reports into it?
That's my understanding, yes.
You're not a lawyer, are you?
No,
You don't have any legal training?
I do not, no.
You don't have any legal education?
I do not.
You don't have any expertise in corporate forms,
I do not.
forms of corporation?
I do not.
You don't have any expertise in the forms of companies?
I do not, no.
You don't have any expertise in forms of government?
I do not.
You don't know whether South Sound 911 qualifies as an independent contractor?
I do not know that, no.
You don't know whether South Sound 911 is governmental or quasi-governmental?
Honestly, I don't know.
Isn't it true that you don't know whether South Sound 911 meets the legal definition of a government entity?
With no legal training, no, I could not say that it meets the legal definition, correct?
No further questions.
Redirect.
No redirect, thank you.
For the state, may this witness be excused?
Yes, please.
For the defense, may this witness be excused?
Yes.
You are excused. You may step down.
Thank you, sir.
The state may call its next witness.
Here are state rests.
Defense?
No rebuttal, Your Honor.
Does the defense rest?
Yes.
Members of the jury, at this time, well, it's going to be, are there lunches here? I should ask that first. All right, they're on their way. So your lunches are on the way. I'm going to have you retire to the jury room for lunch. There is some matters I need to talk with the attorneys about. You've heard the testimony in the case, but I need to discuss with them the law that the court should instruct you on, which I talked about this at the beginning of the case, so now we're developing what that will look like, and then we have to make a lot of copies for everybody once I decide what the law is. So that does take a little bit of time. Thank you for your patience. No talking about the case with anybody and no research about the case. So at this point, the jury may return to the jury room. The jury has exited the courtroom. Everyone may be seated. Defense, anything, argument you'd like to present on your motion to dismiss count?
One moment. Your Honor, we move to dismiss count 2 for lack of evidence that Mr. Shadle is a public servant. His testimony today did not establish facts from which a reasonable juror could find beyond a reasonable doubt that he is a government employee. He testified himself. He doesn't know whether South Sound 911 is a government entity. And he testified that he has no legal training, no legal education, no expertise in government forms, no expertise in corporate forms. He did not provide sufficient evidence to have this case go to a jury, this charge go to a jury, so we move to dismiss count 2.
State.
Just the brief response of before, that it's a weight, not an admissibility issue. He testified that he works for South Sound 911, how it was created, that it's a government entity, and that he's an employee of that. And they can certainly argue that in front of the jury, but it is a halftime motion, so taking all inferences in the light most favorable to the state believes there is sufficient evidence for the jury to decide this issue.
Defense, last word.
Nothing further. Thank you.
State versus Salinas, 119 Washington 2nd, 192, a 1992 Washington Supreme Court case. Cites the case of State versus Green, 94 Washington 2nd, 216, a 1980 Washington Supreme Court case. The test the court is to use concerning, with respect to the defense motion to dismiss count 2, is that the test for determining sufficiency of the evidence is whether, after viewing the evidence in the light most favorable to the state, any rational trier of fact could have found guilt beyond a reasonable doubt. When the sufficiency of the evidence is challenged in a criminal case, all reasonable inferences from the evidence must be drawn in favor of the state and interpreted most strongly against the state. A claim of insufficiency admits the truth of the state's evidence and all inferences that can reasonably be drawn. The defense previously moved to dismiss count 1, the false reporting statement, and the court went through a lengthy discussion as to the facts in the light most favorable to the state. The court's going to incorporate that here. There's no need for the court to repeat that. Specifically for count 2, making a false or misleading statement, the state must prove that the defendant knowingly made a false or misleading statement to a public servant, and that's been the issue, and the statement needs to be material. That's what I discussed earlier. So the issue, as the defense has raised, was a false statement made to a public servant. RCW 9A.04.110, parenthesis 23, defines a public servant to mean any person other than a witness who presently occupies the position of, or who has been elected, appointed, or designated to become, any officer or employee of government. So it's any person that is an employee of government is defined as a public servant, which would then be incorporated into the false or misleading statement statute. Assuming that all the testimony of Mr. Shadle is correct and is true, which the court is required to do at this stage, there is sufficient evidence that Mr. Shadle is a public servant under the making a false or misleading statement. So for those reasons, the defense motion to dismiss count 2, the false or misleading statement, is denied. Anything else from the defense on that?
No.
From the state?
No, Your Honor, thank you.
We do have 15 minutes here. The court did get a chance to review the the defense proposed in jury instructions. And as I did with the defense, I'd like to go through with the state and see if the state has any objection to the defense proposed instructions. We've already talked about some of them briefly, but I do want to know the state's position on it. So is the state ready to respond with respect to the defendant's proposed instructions to the jury?
Yes, sure, in 30 seconds, I'm just reading from We're ready.
And I said I was going to start with the state, but I want to clarify what I think. We'll start with the state's, the defense proposed WIPIC 401. And in looking at this, it looks like it's similar to the state except for the abiding belief language. But is that the change? And if not, what other changes may there be from the defense perspective?
That is the change. It's the removal of the last sentence of the state's instruction about abiding belief.
And I think that's bracketed in the WIPICs.
Exactly.
State.
No response other than we prefer ours.
Fair. All right.
Well, the bracketed information is optional, but I think it is helpful to the jury, and that's why we included it.
I can say, as a former lawyer, based on the side I have argued both your sides, and I was convinced I was right when I argued both your sides. The abiding belief language, it's ancient in our law. It used to be part of the WIPIC that was not bracketed, and then I think the WIPIC committee, I'm sure the WIPIC committee then looked to say, should we keep that in? Case law supports it, and the WIPIC committee, and I was a longtime member of the WIPIC committee, is guided by, if it's the law, you say that's what the law is, you don't make policy decisions about that. So the WIPIC committee is limited from that. And so when they decided to make it brackets, it was realizing that the case law affirmed an instruction that gave it, but doesn't necessarily say it's required. I'm going to give the defense version of this. It doesn't, I don't believe it harms the state's ability with respect to what reasonable doubt means, and to be honest, if the defense wouldn't have proposed their own, I would have given the state's. I think this is an area that could use clarification, but both are correct. And so since the defense is asking for this one, the defense is I'm gonna give their version of WIPIC 401. Of course, then we'll take exceptions when we get to those, so the state can respond if they want. All right, to the state, WIPIC 126.15, and then the RCW is about the definition of false reporting. Does the state object or not?
Yes. It seems to, you want to know the basis?
No, I just wonder if you're going to object, because when we get to the basis, I want the defense to go for, on their instructions like I'll do with yours, to argue why you think that's correct. So for now, I just want to know which ones you object to. Cause, proximate cause, object?
Yes. Yes, we object.
The false reporting to convict?
Yes, we object.
The next one, WIPIC 2.22, modified by KLB, about public servant definition.
No objection to that one.
The court will give that instruction. Definition of knowledge. Looks like in this one, the second, knowledge has multiple paragraphs, and if I read this correctly, it looks like the second paragraph was deleted from the state's, but I may be wrong about that. So defense, the change in this from the state's version?
Yes, the second paragraph is deleted.
Is the first paragraph modified from what the state requested?
Yes, I believe it is.
All right.
I have too many tabs open, so it's trying to go through them. Yes, it is.
State.
I don't have all those tabs, but I need a bigger table. Hold on. And they didn't just delete the second part of the WIPIC.
Is it fair to say the state objects?
Yes, yes, Your Honor, sorry about that.
Other than what the defense has, provided to the court on proposed instructions of the jury. Do you have any other instructions you'd like the court to consider?
Not at this time.
The court's going to start with the state's objections or state's instructions, and then I know the defense has indicated some they object to, so I'll go ahead and let the state start with why its version, and then it looks like there may be some contrary versions, and then I want to hear the defense argument as well. So the first item, so let's start from the beginning with the state's instructions. Oh, any objection, I didn't ask this. Any objection to the cover page that the state provided under WIPIC 101.01? Just, it says court's instructions to the court, dated, and then my signature. This one?
The one that says plaintiff's proposed instructions?
Well, no, this is the first page, but the second one, this would typically be,
Oh, sorry.
although I do say it's not a Sultan County, so we got to change that. But it's the one that would, in fact, I think,
Yeah, the Sultan County part, I would remove.
Oh,
and actually I see the defense prepared one as well called Court's Instructions to the Jury. So I'm glad we caught that. So to the state, any objection to using the defense proposed Court's Instruction to the Jury? It's WIPIC 101.01, does say Pierce County.
yes, let's use theirs with the correct county.
Instruction, we already talked about the WIPIC 102, defense had no comment. The WIPIC 301, separate crime, defense, you wanted to reserve on that?
No comment now.
Okay. The next one, we already talked about, and the court already telegraphed what it was going to do, but it's the WIPIC 401, and that the state's proposing with respect to abiding belief. We've talked about it. I'm going to give the defense version. State, anything you want to say about that?
No, Your Honor.
Defense objected to WIPIC 6.41, weight and credibility of out-of-the-court statements of the defendant. So state, why would you like that to be given?
I think it's an accurate statement of the law, and therefore I think it should be included, particularly in a case where the case really is all about the statements that were made out of, well, not completely, but to a very large extent, that's exactly what this case was about, what people said at the scene, what they said to 911. These are all party admissions by the defendant, and I think that the context and nature of those statements is at the heart of this case, and therefore I think it would be helpful to the jury to have that.
Defense.
This instruction, based on the comments, is used for if there's a confession, a challenge to a defendant's confession, the voluntariness of it, and that's not an issue in this case. It says that the instruction is unnecessary when the prosecutor offers an alleged confession to a private person. Anyways, the entire comment section is that this is to be used for confession cases, which this is not, so we'd object.
Okay.
No response beyond what I was saying.
Yeah, looking at WIPIC 6.41, the note on use by the WIPIC committee starts with this instruction must be given upon request of the defendant when after a hearing, and then goes from there. The defense is not requesting this instruction, and to the contrary, the defense objects to this instruction. Given the reasons for this instruction and the comments that are made by the WIPIC committee, the court is going to decline to give WIPIC 6.41 as proposed by the state for the reasons the defense has discussed. The next one, defense is an alternate from WIPIC 126.15. This is definition of false reporting. So state concerning your proposed version of 126.15.
Your Honor, ours is taken directly from the WIPIC, and it's taken directly from the statute. Theirs adds some elements that are not in the statute, and that's why we think ours should be used.
Defense, I have both of them right here now, so your response.
The false reporting statute includes under section 6 that nothing in this section will be construed to impose liability on a person who contacts law enforcement for the purpose of or in connection with the reporting of unlawful conduct. So if a person, what that says is that a person can't commit false reporting if they contact law enforcement for the purpose of and in connection with the reporting of unlawful conduct. So I think it's an accurate statement of the law, something a jury needs to decide.
You're referring to RCW 9A.84.0406. Is that correct?
Right.
State.
Your subsection 6A's reference to liability is to civil liability, not criminal liability. The rest of subsection 6 deals with civil statutes, so 6A logically also deals with civil liability. 6B deals with clarifying that there is no conflict with the Communication Decency Act, which similarly protects good faith reporters of lewd materials on the internet from civil liability. And then C2, 6C clarifies that there's no conflict with 42 U.S.C. 1983, which governs civil suits based on violations of constitutional rights. This is about civil liability that may or may not attach to this. Now, a principle of statutory construction is that a single word in a statute should not be read in isolation. That's from State v. Rodenkamp, 153, Win 2nd, 614, 2005 case. Instead, the meaning of words may be indicated or controlled by those in which they are associated. State v. Jackson, 137, Win 2nd, 712, a 1999 State Supreme Court case. So in summary, because section 6A's references to liability are the same, 6A's reference to liability is in the same subsection as other terms respecting civil liability, it's also a reference to civil liability. Now, more importantly, this isn't part of the WIPIC, and the reason it isn't part of the WIPIC is it's not an element of this crime. Okay, the elements are listed in subsections 1 and 2, and this is not listed in either one of those sections, so it's not an element of the crime. They've added it to the WIPIC and are asking the state to prove a negative beyond a reasonable doubt. So it's clearly not an element, and even if the court were to read into the language of that statute, it requires actual unlawful conduct, and the call to 911 did not include any actual unlawful conduct. Driving around late at night is not unlawful. None of what is described is per se criminal, and there's no evidence that Mr. Altheimer committed a crime of any kind. Subsection 6 cannot serve simply to protect good faith reporters of something that is possibly, but not upon further investigation, not unlawful. That would be redundant with the requirements of subsection 1, which already protects good faith reporters by requiring that the prosecuted person know that the report is false. So reading subsection 6 as redundant with the falsity requirement of subsection 1 is not permitted. Statutes must be interpreted and construed so that all the language used is given effect with no portion rendered meaningless and superfluous. Also, the statute has to be read to avoid absurd results, and courts also presume that the legislature does not intend absurd results and, where possible, interprets ambiguous language to avoid absurd results. And the reading here seems to be that, if I understand it correctly, if you call in a false report that triggers an emergency response, but then you also add in some of this other language about something that isn't an emergency, that somehow you're then shielded under the statutes from being prosecuted. And that's clearly an absurd result. It's not in the WIPIC because it's not an element, and it's not an element because it is a separate subsection at the bottom of the statute, which is specific to civil liability.
Mr. Rose?
Subsection 6 refers to the section being the entire section. The word liability, it doesn't say civil liability. There's, of course, criminal liability. That goes without saying. While this describes that it does not impose liability for a certain thing, the other two are not in line with that. They talk about conflicts of law. Subsection A doesn't deal with conflicts of law at all. So what Section 6 seems to be is a catch-all provision that describes both conflicts of law and also that the statute may not be violated if you are contacting law enforcement to report unlawful conduct. And it's not an absurd result that this part of the statute exists because in fact it's exactly in line with what I've been arguing as far as proximate cause. The state, if a person calls 911 or law enforcement to report unlawful conduct, the person does not violate the statute by or unlawful conduct that could generate an emergency response. The person does not commit false reporting by also reporting false statements. So it's not an absurd result. In fact, it makes perfect public policy sense. So I disagree with that. And finally, if the court finds that liability is ambiguous, again, that goes to the rule of lenity, and that has to be interpreted in favor of the defendant.
Does the defense, looking at Section 6A, impose liability on a person who contacts law enforcement? Is South Sound 911 law enforcement?
That's a question for the jury to answer.
What element in the false statement concerns law enforcement?
The emergency response section.
So the defense theory would be that the 911 is a law enforcement agency.
No, the theory would be that the purpose of contacting the dispatcher is to contact law enforcement, to get in contact with law enforcement.
Anything else?
Nope.
Just briefly, that, again, the elements here are in subsection 1 and 2, and then after that, you get into things like definitions, what to do if somebody's under the age of 18, that would be a diversion under subsection 4. So anything below 2 is not an element here, and that's why it's not in the WIPIC. And it does pertain to civil liability. That's a clear reading of that statute, and the court's point is well taken as well.
Anything else, Mr. Rose?
No.
The court is going to give the state's proposed version of 126.15 and deny the defense version for two reasons. The statute that the defense is raising, Section 6, mentions liability, and when you read that statute as a whole, it's focused on civil liability. When you look at the specific items that were in parts B and C, a logical reading of that is concerning civil liability. Even if the court's incorrect about that, A, which is what the defense is relying upon, is that when someone contacts a law enforcement agency with possible unlawful behavior, and there's no evidence, the courts heard, that South Sound 911 is a law enforcement, and so for that reason it wouldn't apply, even if this Section 6A is intended to apply to criminal liability as well. So for both those reasons, the court's going to give the state's version of 126.15 and deny the defense version. The next state instruction is the to convict instruction for false reporting. The defense has provided an alternative. So, to the state.
Sorry, I was looking for a cough drop.
Which one are we looking at, Your Honor?
It's it's the one that starts with two convicted defendant of a crime of false reporting in the state's version, and the defense has a separate version with, looks like it's added a new paragraph 4 in just comparing the two. So it's a definition, it's a to convict instruction for false reporting.
Should I go first?
Yes.
Yeah, sorry, I just needed something for my throat. Yes, there's adds an element, which is element 4, which is what we just talked about here. It's also asking the state to approve a negative. It's also not in the WIPIC, so I don't think that that is an element of the crime, and therefore it needs to be removed.
Defense?
I'll just incorporate my argument about the previous instruction.
Understood. So the court is going to give the state's proposed RCW 9A 84040 to convict instruction concerning false reporting, and will deny the defense version, which adds a new paragraph 4. The next is WIPIC 2.22, the definition of public servant, and the defense has an alternate definition, state.
I actually agree with the state's, I agree with the defendant's version. So I withdraw ours and ask that the court use theirs.
Defense?
That sounds good to the defense.
Next is the state's WIPIC 2.12, definition of governmental function. A second, I need to change my notes here.
And just to clarify, our request is to strike this one.
And we've moved to, I just need to glance at it to be sure, but I think we're going to withdraw it again,
Okay.
as soon as we find it. We're going to withdraw that instruction, Your
Just,
Honor.
on the prior one, I made an incorrect note, and I want to make sure my notes are correct, so my apologies for that. So, concerning the WIPIC 2.12, state is withdrawing. Is that correct?
Yes, Your Honor.
Any objection?
No.
Next for the state is WIPIC 10.02, it's the knowledge knowingly instruction. The defense has an alternate version. State.
Your Honor, the state says the WIPIC, which includes all three bracketed definitions of knowledge, all of which I think apply here, but more concerning is that they've inserted in theirs language that isn't in the WIPIC and isn't supported by the law when he or she is actually and subjectively aware of that fact. That is not an accurate statement of the law, and I think it needs to be removed.
Removed, or is the state still seeking its proposed 10.02?
Yes, Your Honor.
Defense?
I think it is an accurate statement of the law, and the comments to the WIPIC support it. The language of, let's see, sorry, just give me 1 second to pull it up. The WIPIC language says that he or she is aware, and that the comment in the actual awareness section says the person must be, quote, actually aware, end quote. And it also says that actual subjective knowledge is required. And it cites the case, Supreme Court case of State v. Ship. So it's an accurate statement of the law. And I think that more explanation is needed to the jury about what aware means.
Dave?
There, I think the definition of aware is well known to everybody. I haven't read that case specifically, but like I said, the WIPIC does not insert that language. And if the WIPIC committee thought that that was something that the jury needed to be aware of, they would have inserted it.
Anything else, Mr. Gross?
I just asked this court to give the instruction that we proposed in full.
The court is going to give the state's WIPIC 10.02 and deny the defense modified version of that instruction. Switching to the, were there any other than what we've talked about to the defense, was there any other instructions about the state that you would want to have the state's proposing, other than what we've already talked about?
I just want to make sure that we move to strike 2.12, that one was withdrawn, I believe. Okay. And the court declined to give instructions 6.31 and 6.41.
Yeah, I know the answer to the first question was the court did, but
That matches what we have.
yeah. So the court's not giving WIPIC 2.22 and 2.21, that's correct. That was withdrawn by the state, so the court's not going to give that. And so, court is going to give defense version 4.01. Declined WIPIC 126.15 modified. Approximate cause. So the defense, you proposed definition of proximate cause based on state versus Buyer, and the state's objected.
If it's okay with the court, I'll incorporate my argument earlier as to the motion to dismiss count one as far as why proximate cause is the right instruction for this case.
Right? Anything else from the state on that?
No, Your Honor, thank you.
The court's going to decline to give the defense proposed instruction approximate cause for the reasons we've already talked about.
Frank, did we address with it 2.11? I'm not sure we addressed that one.
Provided, proposed by the state,
Yes, Your Honor.
2.11.
Yeah, the defense didn't take exception to this one.
Then, okay, I'm just making sure it's been given.
Okay. I think we've talked about all the instructions. I have a couple questions about order of the instructions, but to the defense, have we talked about all the instructions at this point?
As far as I'm aware. And
state-
again, what I'd like is if the court could send us copies, we could review them over lunch and.
We'll see how quickly I can get to them, but yes,
Okay.
that's a goal for sure.
Okay.
But it's going to take a
Yeah.
while to make the copies.
So thank you.
With respect to the order, the defense, and the court agrees, I think I'll start with this. With respect to the order, it's my general practice for a crime, to start with the definition, include all the elements that the parties have requested, and then end that discussion about that particular charge with the to convict instructions. So that's generally the order I prefer, but I'm certainly willing to modify my perspective because there's no real instruction from the WIPIC committee as to how the orders should be. The state also had one final one at the end about the juror's duty to discuss, and I've already indicated my preference would be to put that much further ahead in the discussion, so the juries are told very quickly they have a duty to discuss, but it doesn't matter the order in the sense that the jurors are going to be expected to follow all the instructions. So if you have thoughts about the order of what you would like, let me know. State?
Your Honor, the state really has no preference.
As far as the order definition of this crime, definitions relevant to determination of the crime and to convict instruction, that's fine with defense, the order that the court stated. We would prefer to have the duty to discuss instruction given at the end, just because we think it's good for the jury to hear that just before they go in, sort of procedurally what they should be doing, and have that top of their minds when they start deliberating, but we don't feel strongly.
Well, the state proposed to put it at the end. That's where the defense wants it, so that's where I'm going to put it unless you have an objection. And interesting discussion I'll have to think about, but won't be for this case. So I'll put the whip at 1.04. That'll be the final instruction before the verdict forms. I realize some of this order makes a difference in how you'd want to do closings as well, and that's why I asked about it, because I want to make sure that at least the order is consistent with how you would want it to be told to the jury before closings. So, looks like everybody's on their hands. All right. Yes.
Or there was one more matter about whether or not the exhibits would go back to the jury room with the ability to play them.
We'll talk about that after lunch, but you brought it up, so here we go. So sure, what's the state's perspective on whether the jury should have playback devices in the jury?
What's your perspective? I'm just going to see if we agree or not, because if we agree, then I'm not going to bother making an argument.
This is the case of State versus Castellanos, 132 Washington 2nd, 94. It's a 1997 case.
Your Honor, the parties agree that we'd like it to go back there with the ability to play it, correct?
Correct.
Right. That keeps you from having to come back when the jury sends me a question about that, so I can appreciate that strategy. So we will do that. My understanding is that there's a device that they would be able to put this evidence, these exhibits into, play it, but there's no Wi-Fi connectivity. There's nothing other than the ability to play back whatever they put in there. And I believe there's also a monitor that's attached to the device, clerks are, so that they would be able to see it on a bigger screen than just on a small.
Oh.
What is it a laptop? It's a laptop, but the laptop has the screen's attached, so it's bigger. So that's my understanding of what would go back there. So having no objection, the court will grant that, so we'll make sure the jury has the playback devices. State, anything else?
No, Your Honor, thank you.
Would the jury be able to request to come out here and watch on a bigger screen?
Jury questions are an interesting topic for discussion.
Okay.
It's difficult to predict that. Would you want me to tell the jury they can do that, or would you just want to wait to see if they have a question, then we'll respond and bring them out here if that's what they ask?
The latter.
Wait to see if they want to. I guess wait to see if they want to.
So I'd like to give these instructions to you now, but I have to go through them, make sure they're in the correct order, and then staff needs time to make all the copies, so it's probably not going to happen until after lunch, and I know that may delay everybody, but staff needs a lunch too, and so let's have a lunch and be back here. It's already 12:20. By 1:30, that gives me a few minutes also so let's be back by 1:30 for lunch. Court's at recess.
Recording stopped.